Hello, Law and Society class. Well, we've made it through week 1 of summer session 1, and we are going into week 2. Each week I'm going to try to do a 15 to 20 minute video on YouTube just to sort of give you an overview of what's expected for the week and what we'll be going through. Before I do that, I just want to apologize to all of you for the difficult time in this past week to get the online book. Let me just say, I've never used an online book. We didn't have a choice. We were told that all summer session books would be online and that the publishers and the bookstore were working together to make it easy as can be for students. It didn't turn out that way, and it's not just my students and the classes I'm teaching. I've heard the same thing from other faculty members. So I hope you have all gotten your book. If you haven't, this week just send me an email so that I can try to get you in touch with whoever it is you need to talk to or email. But it seems like everyone has gotten past that, and it certainly was a bump in the road, and I hope we won't have any more of them. Okay, so last week I sort of did an overview and an intro to Law and Society, and this week we're going to be jumping into our first issue. And our first issue in Unit 2, which starts on my page 181. I don't know if it's different for the online book, but it asks the question. And remember, that's what every one of these issues does. It starts with a question. And the question for this issue is, can states ban, meaning prevent, physician aid in dying for terminally ill patients? That is the same issue we've been talking about for over a decade. And the reason for that, you'll see, is that the Supreme Court of the United States has not yet made a decision that says it's a constitutional right, and so they have left it up to the states. And also you will see, and again, I know we went over this before, but the way that each one of these issues is set up throughout the book. So it asks the question, and then we have a yes answer. The yes answer is from a landmark case, a 1997 case of Washington versus Glucksberg that made it all the way to the U.S. Supreme Court. And the then Chief Justice of the U.S. Supreme Court, William Rehnquist, wrote the majority opinion, and the majority opinion answered that question, yes, that yes, states can take it upon themselves to ban, to prevent physician aid in dying for terminally ill patients. So the flip side of that is that what they said in the case before them was that we do not have a constitutional right to demand that if we are terminally ill, that we should be able to go to a physician and that they should be able to assist us in getting a prescription that we can determine later on our own if we wish to take it. Now, I also want to make clear what the legal and medical term terminally ill means, because there are a lot of diseases out there that can be or are terminal illnesses, but they may not fall under the definition. So one of the main things, and you'll see it on a test, is that terminally ill refers to a person who the medical community has determined and believe their best estimate is that the person will probably die within 6 months of their illness. That's terminally ill, okay? Now, as a result of Washington versus Glucksberg, the Supreme Court did not find that physician aid in dying was a constitutional right that a terminally ill person can demand. But what did come out of this back in 1997 that we've all accepted and are pretty much used to is what we refer to as do not resuscitate, DNR orders. Now, DNR orders any person who's at least 18 years old can have a DNR. You don't need a doctor's note. You don't need it notarized, although that could be helpful. If you choose that you do not want life-sustaining treatment of some kind, if you were to say take a heart attack or something would happen, you can have a DNR, and medical personnel will then not resuscitate you. Okay? That did come out. We do have a constitutional right to refuse life-sustaining treatment. Okay. So looking at this, just to get you started, so we have the yes, and the yes comes from the majority opinion. I sent out introductory notes. A majority opinion on an appellate court is, appellate courts are panels of judges, and they review the lower court cases to see if there are errors, to see if they want to agree and not change that lower court decision or overturn it. In Washington versus Glucksberg, the majority opinion here was that, and if you look down at the issue summary, that although patients have a right to refuse life-sustaining medical treatment, physician, and back then it was called physician-assisted suicide, which I'm going to address in a minute, physician-assisted suicide, or what we now call physician aid in dying, is not constitutionally protected, which means we cannot demand as a constitutional right, if we're terminally ill, that our state allow us this. Okay. There is a no here. Now the no comes from Stephen Reinhart. Stephen Reinhart helped write the majority opinion. Judge Stephen Reinhart, he's in the Ninth Circuit, which is the intermediate appellate court in the federal system. And he wrote the majority opinion when Washington versus Glucksberg was in the lower courts, and it was called Compassion in Dying versus the State of Washington. And if you look at the issue summary, it will tell you Judge Reinhart, writing for the majority in the lower federal court, which the U.S. Supreme Court overruled this decision, that became Washington versus Glucksberg when it reached the U.S. Supreme Court, argues that criminalizing physician assistance in hastening the death of a competent, terminally ill patient who requests life-ending prescriptions violates the Due Process Clause of the U.S. Constitution. So in the 1997 U.S. Supreme Court decision, Washington versus Glucksberg, when it went through the lower appellate courts in the federal system, they ruled that it was a constitutional right, but the U.S. Supreme Court, of course, has the last say, and when they decide a case, everyone has to follow it. Interestingly enough, Washington versus Glucksberg was decided in 1997, and don't misinterpret this. This did not say states couldn't establish laws that allow physician aid in dying. All it said was they were going to leave it up to the states, and they were not going to find that it was a constitutionally protected right that could be demanded. Okay, so for almost 2 decades, there was only one state in the entire United States that actually had physician aid in dying, and that was the state of Oregon. So you're going to see a lot of references in both my lecture notes and in the book to Oregon's Death with Dignity statute. Let me talk about, at the time of Washington versus Glucksberg and Oregon's statute, this whole issue was referred to as physician-assisted suicide. You'll see in my notes that I will send to you this week that the term suicide may have actually been the reason why more states did not pass laws, once Oregon did, allowing this. Suicide has a very shady history. First of all, most of the major world religions, most of the major world religions believe suicide is the worst possible sin. And I say that because if you're successful, you can never ask for forgiveness. And suicide at common law, and until less than a century ago, was a crime. So imagine that if someone commits suicide, this is a criminal act. Now, I hope you're saying to yourself, well, if someone commits suicide, they can't do anything to them, they're dead. But here's the thing. At common law, a lot of our laws are based on religious beliefs and moral beliefs. And because suicide was taboo, was the ultimate sin, they made suicide a crime. And the penalty was, if someone committed suicide, that all of their property, their land, their home, their bank accounts, their livestock, everything they owned would go to the state and not to their loved ones, to the people they left behind. They used that punishment as a very harsh deterrent to try and prevent people from committing suicide. So using or referring to this issue in the beginning as physician-assisted suicide from the very beginning was really, no pun intended, but a death knell for this issue. However, a few years ago, states that were interested in following Oregon's lead started changing the name. They did not use physician-assisted suicide. They used the term physician aid in dying. That is the exact same thing as physician-assisted suicide, but because they took out the word suicide, it seems that now we have a trend over the last several years, and that trend has been that more and more states are passing laws like Oregon, and also at the same time are introducing bills that are trying to get their state to create a law like Oregon's Death with Dignity Act. As of the beginning of this year, 2020, in the state of Rhode Island, in the General Assembly, which is our legislative branch, in both the House of Representatives and the Senate, there are two pending bills from January and February of this year trying to pass a law allowing physician aid in dying in the state of Rhode Island. This is not the first time that a bill like this has been introduced, and so it has been defeated before. However, we are seeing more and more people and states accepting this. Now, let me just explain a little bit about how this works. So one of the things we're going to read this week is going to be about the slippery slope doctrine. In the slippery slope doctrine, and it's not only used for this issue, it's used in a lot of issues, but the idea of the slippery slope doctrine is that you may not be against, or people may not be against this idea of physician aid in dying for terminally ill people. However, the slippery slope doctrine says that people want to prevent something like a law like this, not because they might be against the first step, but they are afraid that once we pass a law allowing it for terminally ill people, the next thing we'll start to see is we'll expand it to chronically ill. The next thing we'll expand it to anybody who's ill. The next thing we may do is expand it to any person, ill or not. And so the slippery slope doctrine worries about where passing the first law will lead to. And it also worries about things that could go wrong. You'll see in my notes some of the things that people worry about, that it'll be abused, or that someone who's terminally ill and does not want to get this prescription or use it, but they feel that the cost of their illness is too expensive, or they feel that they're a burden on their loved ones. So there are a lot of things to think of. And you'll see that in the notes, and you'll see that in the text. However, when you see Oregon's Death with Dignity statute, I think that you will get a feel for how the law can address most of those worries that people have about what if this happens, what if somebody else takes a drug, what if. And so this week we're going to be talking about that. Currently, we have 8 states in the United States that allow physician aid in dying, and Washington, D.C. So we have 9 jurisdictions that allow physician aid in dying, and most other states, even though they don't have it yet, have been introducing bills to try and pass these laws. Now, let me also tell you that this is, if somebody is terminally ill and they wish they're in a state that allows this, this is not done in a hospital. If they follow the steps that the law sets out and the procedures, and they get the prescription, the terminally ill person gets the prescription filled and then decides if and when they wish to take it. Now, a lot of people, one of the things they worry about is, what if somebody accidentally takes that? Well, it's not one pill. It is a series of capsules that has to be opened and put in something to drink, so that somebody mistakenly taking one pill, this is already legal drugs, and so they're not going to die from it. But someone who is terminally ill and wants, sometimes just as a safety valve because they're afraid how much pain they may be in, and they want to control that, and they don't want people taking care of them, and they don't want, they want death with dignity. And for some people who are terminally ill, to them that means they are in charge, and if it gets too painful, if there's a problem, they can take it. There's no doctor present. Once you have gone through all the steps and procedures and you get the prescription, you're on your own. No one else can feed you that, or if you are in a drug-induced coma, the person who's terminally ill has to be well enough to say, I'm going to do this, and to do it themselves. So not even through what's called the durable power of attorney for health care, which is where you appoint someone to make medical decisions for you if you're unable. The physician aid in dying is never part of that. The person themselves has to be well enough, within enough, to make that decision. Okay. There is an assignment that you will get on Thursday, and I just want to address it for a minute. Oh, and I've written the definition of physician aid in dying, but let me just give you one. You'll see it in my notes, so you don't have to try to take it down here. But it is when there is a statute passed in a state that allows a terminally ill person, defined as a person that the medical community believes will probably die from their illness within 6 months, to go through the steps and procedures set out in the law, and to obtain a prescription for a lethal dose of medicine. When they get that, it will be their decision on their own, in their own home, not in a hospital or a facility. The doctor is out once you've gone through it and you've gotten the prescription. That's physician aid in dying. Now, you'll see an assignment to interview 2 people later on in the week. And I just want you to remember a couple things. When you interview people, to ask them what they think of this issue, please only refer to it as physician aid in dying. Don't talk about the suicide name that it once had. If someone says that they are in favor of it, at least for terminally ill people, I want you to ask them, would they be in favor of expanding it to chronically ill people, or to any ill person, or to any adult? And also I want you to ask them, would they be in favor of it if it was called physician-assisted suicide? And it's the same thing, same definition, just the title of it has changed. Also, I want to address one thing. As an example of how this one issue is not just this encapsulated issue, but it extends to other things. I just wanted to talk for a minute before I end about insurance. So if you have a life insurance policy, there's a clause in life insurance policies that says if the person dies by suicide, the life insurance will not be paid to the beneficiary. So the question becomes, in these states that allow physician aid in dying as a legal option for a terminally ill person, what happens when they use that and they die? What does their death certificate say? And the states have addressed this. If you die through using the prescription from the physician aid in dying, your death certificate will list as the cause of death whatever the terminal illness is. Therefore, your beneficiary will receive your life insurance policy if you have life insurance. So that takes care of a very important issue that terminally ill people worried about, that they had insurance policies, and that if they took this prescription, would that mean that their loved ones, their beneficiaries, could not claim the life insurance. So that's not a problem. It's been dealt with. Also, we use, because all these states use, the Oregon statute, Death with Dignity, and so you will see the parts of that statute, and I think you'll get a feel for how Oregon and the other states that allow it have tried to think of all the ways things could go wrong and address them in the statute itself. And I think personally that we're going to see more and more states pass statutes, and maybe eventually the U.S. Supreme Court will even hear a case again, a new case, and because they haven't heard this issue, they haven't decided this issue since 1997 with Washington versus Glucksberg. Maybe they'll take a case. However, the makeup of the U.S. Supreme Court right now tends to be more conservative, or moving in a more conservative direction, and because of that, it may be possible that religious beliefs will rule any decision in a case with physician aid in dying where they will not find that it is a constitutional right. But we'll have to see if things have changed since Washington versus Glucksberg, and since states are really taking it into their own hands now. All right, so I hope you have a wonderful week. I hope you don't have any problems. I'll be sending on Tuesday and Thursday a link for this video. I'll be sending you notes. I'll be sending you assignments, all of these things. If you have any problems, if you have any questions, just send me an email at my email and I will answer it. All right, have a wonderful second week of summer session 2020 at CCRI. I look forward to reading the assignments that you get later and send back in. All right, take care. Bye-bye.